Welcome to the Doughty Street webinar on possession proceedings and COVID. My name is Ben Chataway from the Housing and Social Welfare Team. In a minute, I'm going to talk to you about some COVID-specific defences to claims against tenants. And then I'm delighted to say that we've got Alice Irving, who is the newest, brightest member of the Housing Social Welfare Team, who you may have seen already giving a seminar on eviction, and she's going to talk to you about the arrangements for new cases. And then lastly, we've got a familiar face, Dominic Preston, who's going to talk to you about Staid Claims. So before we start, just a word about the format of the webinar. You'll have noticed your microphones are muted and your video's turned off, and that's just to make sure that the Zoom runs smoothly. But we do want to hear from you, and in particular, if you've got questions about the presentation, please do feel free to use the question and answer function that flicks up at the bottom of your screen, and then we'll try and come to those at the end of the seminar. Right, to start with, defences. I'm going to be talking to you really about two things. One is about the new rules on notices of seeking possession, the time frames, and I'm going to look at some of the technical defences that might be raised and why ultimately I think that they've got limited life. And also then talk about the pre-action protocol and the extent to which that might be available as a new ground of defence to a claim for possession. So first off, notices. And there are basically 4 different periods when the notice periods for notices of seeking possession vary. And how this works, I think, is particularly important in the context of claims brought on the basis of Section 21. So we're going to talk through that first. And you'll see on this table on the left are the various periods during which a notice might be issued. And the notice period and the form of the notice depends on when the notice is served. So to start off with, we've got the old rules pre-COVID, and as you'll know, there was a 2-month notice period under Section 21 of the Act. And then afterwards, there's a period from March to August when the 3-month rule was applied. And then from September, the rules were varied again to say there should be a 6-month period for notices. The bits in red are bits that we're going to be looking at in more detail, because they are areas where there's a bit of a doubt about the validity of the form that's being used and also about the period of the notice. And there are some, particularly there have been some questions raised by sharp-eyed commentators like nearly legal about the ways that the rules operate. And ultimately, short story is, I don't think they're going to really run as defences with the court. But if you're a duty advisor and you've got no other basis on which to defend a claim, or you're advising somebody with a Section 21 notice, then they might be worth a try. But we'll see what they are. So to start off with the explanation, go right back to the original arrangement before March. And here's Section 21 of the Act. It'll be familiar to lots of you, I'm sure, saying in the usual one, 21.1, at least 2 months notice in writing. Of course, there's 21.4, which applies for periodic tenancies, similar rule. But importantly, you've got 21.4D, which makes it clear that claims have to be brought within 6 months of the notice being given. So in other words, you used to have a 4-month window. You'd serve your notice, got to wait 2 months, then you've got to issue within 4 months. That was the window for issuing your claim. How did it change? Well, from March, 25th of March, it was changed by the Coronavirus Act itself. And what the Act said was that Section 21 is to be read as if the reference to 2 months was a reference to 3 months. And just note those words, is to be read as, because I'm going to come back to those later. This rule was applied under the Act for what's called the relevant period, which was originally March to September. And so the way it was phrased was, I think, to make it clear that this wasn't amending the Housing Act indefinitely. It was just saying during this relevant period, you read it as though it said something else. So that was the original provision, and no doubt that it was effective. So for notices served after 25th of March, no doubt that they were required to give 3 months notice. What happened then? Well, in August, everything was changed. And this is the provision, this is the way the change was brought in. It wasn't through any acts of Parliament, it was through regulations. And this is what the regulations said. They said 2 things. Firstly, they said that what was the 3-month period is now changed to a 6-month period. And note that the regulations are doing this in a slightly funny way. What they're doing is they're not amending the law, they're not referring directly to the Housing Act. They're saying, well, actually, these regs change the Coronavirus Act so that it modifies the Housing Act in this way. So first it changed 3 months to 6 months. And then also it changed the lifespan of the notice from 6 months to 10 months for obvious reasons, because otherwise it would be impossible for landlords to serve a Section 21 notice if they had to wait 6 months and the notice ran out after 6 months. So they had to extend it to preserve that 4-month window. Well, why is that surprising? And why is there a big red block of text at the bottom? Well, the reason is this is all secondary legislation. These are regulations. So it begs the question, how can they change rules that were set out in primary legislation, originally the 1988 Act, and then the Coronavirus Act of 2020. So how could they do that? Well, they tried to do it through these provisions in the Act. They're called Henry VIII clauses. That's why there's a picture of him stuck up there. Presumably because he liked to delegate stuff while he was out hunting or hunting wives or whatever. And basically, the Coronavirus Act gave authority to the Secretary of State to make regulations that would change the Coronavirus Act, and by doing that, change the other primary legislation, the 1988 Act that we're looking at. And so here, you see the Act said that there can be regulations that extend the 3-month notice period up to 6 months. Now, but looking at subpara B, what they can't do is extend any period to more than 6 months. So why is that an issue? Well, if we look back at that table that we started with, we look back at Section 21, there's no issue here extending the 2 months to 3 months to 6 months. That's fine. You can extend, you can change 21(1) in that way. But what about the limit in 21(4)(d), the lifespan of the notice? That Henry VIII clause doesn't give authority to the regulations to change that 6-month lifespan to 10 months. So this is where, when I was going through it, I began to get quite excited. I thought, well, hang on, what that might mean is the bit in red there is ultra vires. Can't be done. And what that might mean is that landlords can't now serve the Section 21 notice at all, because they've got to wait until 6 months has gone by and the notice has expired. And you might argue that if you've got nothing else to argue, unfortunately, I don't think it will run far. And that's because if you read on in Schedule 29 of the Coronavirus Act, you get the next bit, which is another Henry VIII clause here. And you'll see what it does is say that the power to make regulations extends to a power to make supplementary, incidental, consequential provisions. And I mean, it seems to me that what the court is likely to decide is that the regulations did have power to extend the lifespan of a notice from 6 months to 10 months, not under paragraph 13, but under paragraph 14. And indeed, that must be what Parliament meant, because otherwise it would make the 6-month notice period completely unworkable. So if you've got nothing else to argue, you can raise it. But would it merit legal aid? You might have trouble persuading the legal aid agency that in the long term, it's got a real prospect of running. But that brings us back to that table. What I want to do now is look at this column on the right about the forms. And this is another issue that's been picked up by some of the commentators. And basically there is a glitch about how the changes to the relevant forms for a Section 21 notice have been made. So this is the first stretch, going back to March to August, 3-month period. What the Act did was say that the regulations that specify the form of the 6A, the usual Section 21 notice, should be read as if the form set out in the schedule referred not to 2 months, but to 3 months. And the issue that's been raised is, well, what does that mean? Does it mean that landlords are required to use the old form, which, although it in printed text refers to 2 months, should be read as if it refers to 3 months? Or does it mean that actually landlords are required to use a new form, which is based on the schedule read through the lens of the 2020 Act, and therefore landlords ought to be serving a new form that refers to 3 months? I mean, my own view is that it's pretty obvious it means the latter. There was a new form posted on the government website, and I mean, it seems to me that the argument only arises because of these words "is to be read as if," which appear in the 2020 Act. But as we've seen right at the beginning, I mean, that's the form of words that the Act uses when it's talking about the primary legislation, the 1988 Act and Section 21 itself. And the obvious reason why it uses those words rather than simply amending the legislation is because the Act is imposing a temporary measure that only applies for the relevant period. It's not seeking to bring about any indefinite change in the law or in the form of the notice that should be used. So again, it's an argument. You might raise it if you've really got nothing else to say, but unfortunately, I don't think it will run. So that's Section 21 notices. What about other forms of notice? Well, this table, as you'll see, deals with Section 8 notices. So in other words, you've got a assured tenant, and there's some other ground for possession. Of course, there are all sorts of other tenancies. You've got secure tenancies, introductory, demoted, etc. And there are different rules that apply. And if in doubt, you're going to need to look carefully at the rules for those as well. But just to illustrate the points that arise, we're going to focus on Section 8. And I want to make 3 points really about these kinds of notices. The first is that you've got a very similar last resort argument that relates to the notice period. And this explains why you've got that bit of red text. For the period August 2020 to March 2021, that queries whether the current rules for a notice period for antisocial behaviour claims, in other words, notices based on ground 7A and ground 14, are well, what the rules are. So here's the issue. We're looking back at these regulations that change the notice period from August. And as I said with Section 21, the secondary legislation, their power to change the notice period only arises because of those Henry VIII clauses in the schedule. And for the reason that this argument arises in relation to ASB claims is because of the way the Act or the way the regulations work for those sorts of notice. Basically, what the government's done is it started off with your old notice period for ASB claims, which under ground 14 could, there was no notice period. You could start proceedings as soon as the notice was served. It then imposed from March to August that 3-month period, and then it took it away from August. And this is how it does it. It does it through the regulations which purport to suspend the Coronavirus Act. And so basically what it's doing is taking away that 3-month amendment and leaving in place the old rules. Well, how can regulations suspend an act? They can only do it under those Henry VIII clauses. And of course, the words suspend don't appear in those Henry VIII clauses. So there is a question mark about the effectiveness of the regulations, whether they're ultra vires or not. I mean, again, I unfortunately, I don't think the argument is going to run far, because although the wording is about suspension, the mechanism chosen is suspension, the effect is to take what was a 3-month notice period under the Act and basically remove it to a no notice period. So the effect is broadly what paragraph 13 intended, and insofar as it's not covered by paragraph 13 of the Act, it seems to me it's an ancillary change that falls within paragraph 14. But as I say, if you've got a mandatory claim for possession on 7A, for example, no other argument, it might be worth the run out. So back to the table, that deals with the notice period. What about the form of notices? And the same issue arises in relation to section 21. The wording of the Act is slightly curious because it refers to the Form 3 being read as if it referred to new notice periods. Personally, I think that probably is effective. But again, there's an argument that you ought to be using the old form of notice and pretending it says something different. What next? Just a summary, really. Where are we now? You'll have seen that there's a whole range of different notice periods that apply depending on the type of tenancy and the ground of possession relied upon. Actually is not as complicated as it looks, because there are broadly 3 classes of claim. There are claims brought on the basis of some sort of serious wrong, antisocial behaviour, rioting, domestic abuse, obtaining a tenancy by false statements. They're the ones where the current law is broadly the same as it was pre-COVID, so short notice periods on the whole. And then there are rent arrears claims, and for here there's a new sort of variable period. Basically, if the arrears are under 6 months, landlord only needs to give 4 weeks. If they're over 6 months, it should say, the landlord needs to give 4 weeks notice. But if they are under 6 months of rent arrears, then the landlord needs to give 6 months notice. That rule is slightly odd in the way it works. I mean, if you imagine you're a landlord, you've got a tenant, they owe you 5 months. What's your choice? Well, you could serve a notice now, which will have to say proceedings won't be begun for 6 months. Or you could wait 4 weeks. If the tenant doesn't pay up, then you could start your notice, serve your notice and only give 4 weeks and start your claim after that. And then lastly, you've got all the other grounds, breach of tenancy, other breach of tenancy, and so on. And for those cases, there is now a 6-month notice period. So it's not as complicated as it might seem. That's notices. Now, I want to just talk also about the protocol. And we're all familiar, I expect, with the pre-action protocol that applies to claims brought by social landlords against tenants. And the protocol has, the current protocol has been there since 2015. And it has always said that if the landlord unreasonably fails to comply with the terms of the protocol, the court may make an order striking out or dismissing the claim. My own experience is I haven't seen a claim struck out purely on the basis of a landlord's failure to comply with the protocol. And why? Well, I don't think the court can strike a claim, or at least could strike a claim out purely for failure to comply with the protocol. Why? Because the power to strike out comes from CPR Rule 3.1. And 3.1 draws a clear distinction between breaches of the rules and breaches of the protocol. So you have got at 3.14 specific provision saying that if there's a breach of the protocol, the court may order payment of a sum of money, or for example, or impose a cost provision. But the same part says the court may strike out a statement of case if it appears to the court that there's been a failure to comply with a rule, practice, direction, or court order, not a protocol. And protocols are statements, ultimately, they're statements of good practice that are expected to be followed. They are not in themselves a rule or a practice direction. So query whether the protocol that applies to social landlords was really accurate when it was saying if you don't comply, you might be struck out. So what's changed? Well, what's changed is the new COVID practice direction, PD55C, which Dominic is going to be talking to you about in more detail. But one aspect of the new practice direction is this requirement, which doesn't apply to old claims, doesn't apply to old Staid claims, but it does apply to any claim brought on or after 3rd of August. And what it says, among other things, is that the claimant must bring to the hearing a notice confirming that the claimant has complied with the pre-action protocol and detailing how. So there is an argument that the effect of this practice direction is, in a sense, to incorporate the protocol. And if you don't comply with the practice direction by confirming that you follow the protocol, that might be a basis on which the court could strike out a claim. That all seems a little bit tenuous, but it's the whole environment, of course, that has changed as well. And one of the things that Alice is going to be talking to you about is the new overall arrangements, which are broadly guidance published by the Master of the Rolls, dealing with how cases are going to be dealt with. And the overriding message from this stuff really is that we're in a new environment. There is now an enormous backlog. There are lots and lots of parties to court claims who are waiting. There's a huge burden on the court. And in that context, it seems to me that there is going to be a whole new focus on compliance with procedural rules. Because if those rules aren't followed, and if cases are delayed or adjourned as a result, this backlog is simply not going to be manageable. So it gives a whole new flavour to the overriding objective of the CBR. And indeed, what the overall arrangements say is that where a pre-action protocol applies, it must be complied with, and compliance will need to be shown. So it does seem to me now that if you've got a new claim for possession by a social landlord and they haven't complied with the protocol, you ought to be arguing that it should simply be struck out, because the pressure on the court system now is such that step is merited. Of course, that may or may not work. Broadly, what the case law says on the power to strike out under Rule 3 is that you apply something like the Mitchell guidelines. And you also ask whether the sanction that you're going to impose is proportionate. And you can see landlords will be saying, look, our substantive legal rights haven't changed, and it would be disproportionate to strike out. But it really is, I think, worth a pop under the new arrangements. And indeed, the arrangements go on to say that at this new stage, which Alice will be explaining, the review date, if the claimant's documents are not in order, the court can be expected to dismiss the claim. And it seems to me the gist of it there is again, we're under such pressure. You've really got to, if you're a claimant, get your act in order. And if you don't, your claim might be struck out. So that's a bit of a canter through the rules, but it seems to me there are some of the defences that some of the ways in which the law and the procedure has been changed, and you might be able to raise a new ground of defence following the COVID changes. I'm going to hand over now to Alice, who's going to be talking to you in much more detail about the new listing arrangements.
Fantastic, thanks so much, Ben. Now I believe I have charge of your screen now. Let's see if that works. Excellent. So I'm going to be talking specifically about new claims, and that's defined in the new Practice Direction 55C as claims brought after 19th of September. And I'll be dealing with the new regime that's largely set out in the overall arrangements about how listing is to occur in relation to those claims and some of the issues that might arise, the kind of moments that you might be able to effectively intervene on behalf of defendants, given the new regime. So I've just got a slide here of resources which are relevant to new claims and indeed, in fact, are relevant across the board really to all of the talks today. And we will be putting these slides up online, and these are hyperlinked, so you should be able to click and pop through to those documents. I would draw attention in particular to the third bullet point there, which is the Ministry for Housing, Communities and Local Government have put out a host of guidance for landlords and tenants, and their specific guidance targeting social landlords, social tenants, private tenants. A lot of that content simply sets out and explains what's in PD 55C and the overall arrangements, but there are a couple of other points I'll draw out in the course of the talk that might be worth thinking about, and certainly the tenant kind of focus guidance has some useful checklists of things to look out for, although I'm sure that the duty advisors watching this won't need the assistance of the ministry there to ensure that they're across the things to look out for. I think I have a bit of a delay in moving the slides, Ben, when I'm controlling, so perhaps I might ask you to do it since it's not working very efficiently for me. Brilliant, thank you. So one of the key things that Ben has already touched upon briefly at the end of his presentation is that in relation to new cases, there are new notice requirements. Now, Dominic will be talking about the reactivation notices that have to be served in relation to old Staid claims. Those obviously don't apply in relation to new cases that are issued or filed. Nevertheless, there is a requirement for a notice of a different sort to be filed, confirming, as Ben noted, compliance with any applicable pre-action protocol for social landlords. And also the second requirement, which is setting out what knowledge the claimant has as to the effect of the coronavirus pandemic on the defendant and their dependents. Now, there is no current pro forma version of a notice available online, but you will note that when we get to the reactivation notice discussion that there are template reactivation notices available online, and you might sort of steal the wording from those in relation to these notices for new cases as well. I think we've popped on a little bit too soon to the next slide, but nevertheless, the notice, which I'll call just sort of COVID knowledge notice, must be served on the defendant not less than 14 days before the hearing, and the claimant must also bring copies of the notice to the hearing. So just checking that all of that's been complied with, that's information that the court should have, and they may adjourn if they don't have it. And particularly, and I'll cover off accelerated possession procedures in a separate slide, sort of drawing all the threads together, but do note that in accelerated procedure cases, a notice setting out knowledge of the impact of the pandemic on the tenants should be filed, must be filed with the claim form. So again, that might be something that you would be looking out for to see if that's missing, if you happen to get your hands on an accelerated possession claim. So just looking perhaps at the next slide, if we may. So knowledge of impact, I think it's been pointed out by commentators that while the practice direction requires you to set out what knowledge you have of the impact of the pandemic on the defendant in proceedings, that there's no corresponding legal duty to carry out inquiries. And the question naturally arises, well, is it sufficient then for a claimant in possession to proceedings to say, I don't know anything? And we've certainly heard that people have been doing that in reactivation notices that have already been put in to the courts. The only thing I would say that's sort of developed in that picture is that the guidance I referred to earlier, both the guidance that's applicable to social landlords and also to private landlords, have equivalent provisions in them. And they say that I've got quoted here, if you have no knowledge, you should make this clear, including information about any attempts made to discuss matters with them. And if you do not provide this information, your claim will be delayed. So this does suggest that if a landlord has made absolutely no effort whatsoever and simply says, I know nothing, doesn't set out what steps they've taken to perhaps inquire, that a court might be minded to adjourn a case off to allow more information to be gathered. And that's promising, at least, that hopefully landlords won't get away with just saying, you know, I don't know, and therefore I've discharged my duty under the practice direction. But obviously this is just a guidance document. It's not statutory guidance either, so it's not technically binding on the court, but I think it's something you can point to if a judge is minded to sort of flag something through, even though there is no information available to the court about the impact of the pandemic on the defendant. Okay, now one of the other things that comes up in the overall directions or overall arrangements is this new concept of COVID-19 case marking. So the idea is that a case file can be marked where the possession case is sort of linked to COVID-19. So where the claim is as a direct consequence of COVID-19. Either party can request for the case to be COVID-19 marked. We would anticipate it would more often be defendants making this request, although there is also provision for a claimant to make a request and to point out why they need to have possession of the property because of how they've been impacted by COVID-19. It's not an automatic procedure if you make a request for the case to be COVID-19 marked, that it will be marked. The other party will be notified. If they don't object, then the case will be COVID-19 marked. But if there is an objection, then it will go before a court to determine whether or not it should be marked on the papers. Now, there are a couple of questions, I think, to explore here about what kind of cases might qualify for COVID-19 case marking. And the warning that I've drawn out there is again from this ministerial guidance or ministry guidance rather than from the overall arrangements itself. But there's a sort of fairly stern warning to defendants there to not mislead the court and to seek COVID-19 case marking if it's not truly applicable to your case. And you'll see at the end of the quote there that principally they anticipate this being where COVID-19 has impacted on your ability to pay rent. So I think it's fairly clear that COVID-19 case marking will apply to related cases where you've got COVID-19 related arrears. The question I have is whether it will apply to cases of COVID-19 related antisocial behaviour. So thinking about that, I had an hoarding injunction last week where one of the complaints made against an individual was a failure to comply with the government lockdown requirements. But also it's fairly obvious perhaps that during lockdown and the various pressures that have been placed on people during the pandemic, it may be the case that certain factors that lead to antisocial behaviour have been exacerbated. And you might want to say something like, you know, we can give an undertaking, or we can ensure this isn't going to happen in the future because some of those stresses have been reduced, although that may be less promising now we see ourselves perhaps being locked down again soon. Nevertheless, it's not entirely clear whether the case marking procedure was intended to apply to those kinds of circumstances. Nevertheless, I don't see that you would be misleading the court if you were to set out your circumstances and make it clear that you weren't seeking case marking on the basis of rent arrears, if that wasn't applicable. And then it would be for the other party to object if they thought this wasn't an appropriate use of the case marking, and for the court to determine the matter should the other party object. So why might a defendant want to case mark their file? If we could go to the next slide, please, Ben. Thank you. The first point is perhaps a little bit optimistic, but the key theme through all of the documentation, whether that be the overall arrangements or the guidance issued by the ministry, is that there's a really firm emphasis on matters being settled out of court if possible at all. And again, that's echoed that in the guidance to landlords, that if a case is marked, you'll see when we get to the next slide that the defendant will have to provide certain information. This might be information that, for example, the claimant has not had access to before, and the guidance encourages the claimant to have a moment to rethink at that point whether, in light of this information, they should be proceeding with the possession claim at all. So it's an opportunity to bring to the claimant's attention further information and again to press for settlement short of going through with the sort of possession hearing. It's also fairly clear from the overall arrangements and the guidance that where there are discretionary grounds, the fact of this COVID impact might influence the decision reached by the judge in relation to the substantive decision. Obviously, these are arguments you could raise at the hearing anyway, but there's no harm in having a big marker on the file and ensuring that certain information is before the court. I think the really interesting point, and this comes out of the guidance, is that in accelerated possession claims, if the case is marked, the judge might just direct a review can take place. And that would allow the defendant to receive advice from a duty scheme advisor. And as you're aware, given the accelerated possession procedure, generally things just go to a hearing on the papers, and you might not get a look in as a duty advisor in those kinds of cases. And so if for any reason we're able to indicate to people who've received notice of a claim being brought against them that they maybe should think about case marking, it might make a bit more space for them to be able to access some of the new free legal advice that's been provided in relation to review dates and so forth. So just something that's worth considering in accelerated possession claims. And just on the next slide, this is the information that the overall arrangements say must be provided by the defendant if they're making a request to case mark. And you'll see again that there's a very, very strong emphasis obviously on rent arrears, circumstances relevant to rent arrears here. But I would note that the language is to provide a brief description of their circumstances, including. So I wouldn't say that this is exclusively what you're able to put in information-wise. And I do think it could be possible to try putting in information, for example, about any relationship between allegations of antisocial behaviour and the pandemic, if there is genuinely a connection. If we could move to the next slide. So the new listing procedure more generally. So this is all set out in the overall arrangements. And we've had a bit of a chat amongst ourselves after a useful question was sent to us before this webinar about the enforceability or not of the overall arrangements. So in Ben's talk, he focused quite a lot on, you know, what can we do with the changes that have been made to the CPR? What can we do with the changes or the new 55C? I think, unfortunately, our view is that the overall arrangements, being as they are essentially internal listing documents for courts, can't really be used for the same kind of purposes in terms of leveraging certain defences or anything of that sort. This is because it's essentially an internal matter for the court, how they list and manage cases, which is unfortunate. Nevertheless, here we go. Here is what is set out in terms of the new listing procedure. You might have heard people going on about R dates. So these are the new review dates that have been introduced under the overall arrangements. So the idea is that all new cases will first be sent to an R date. Everyone will get a minimum of 21 days notice before an R date is listed. Now, an R date is not a hearing, and the parties are not required to attend court. In fact, I'm sure they're actively discouraged. Instead, the purpose of the R date is sort of twofold. The first is it's a new point at which a defendant has access to the potential duty scheme advice. And this is almost certainly going to be provided remotely. So they'll get a date, which is their review date, and they'll be given information about how they can access duty scheme advice on that day. So this is an early chance for legal input and hopefully for defendants where they qualify to be signed up for legal aid contracts in the hope that with early legal advice, matters might be resolved or settled, or at least put into a sort of a better format by the time a substantive hearing comes about, if that's necessary. The other purpose of the R date is linked to that, which is it's an opportunity for parties to try to reach a settlement or to agree directions if a settlement isn't possible. So with the input of that duty scheme advisor, in discussion with the claimant, who has to be available on the R date for conversations, generally over telephone, the hope is that some agreement can be reached, if not on the substance of the matter, then at least in relation to directions. And the court will be available to make orders that are agreed, whether that's in relation to the content of the claim itself, or in terms of directions going forward, although the parties wouldn't be appearing before the judge. Again, that would just be a sort of a signing off on the papers on a consent order basis. Now, there shouldn't be any jeopardy at all at the R date in terms of an actual possession order being made. The only circumstance where that could potentially arise is if the parties agree at the hearing that a possession order should be made. But even then, I would suspect that the judges would be giving very, very careful scrutiny to any suggestion that there's been an agreement for a possession order to be made, to make sure that there is in fact adequate advice in place for the defendant agreeing to that, and to ensure that all the sort of legal requirements of making that order are satisfied. The other thing to note about the R date is that linked to that is a new requirement that 14 days before the R date, the claimant has to file a bundle of documents, and you might call that the R bundle. I've heard that referred to if we're going for the new lingo. And that should be the claim form, the defence, if one's been sent in, as well as any of the requisite sort of notice documents and so forth. And the court will be checking on the R date whether all of those documents are in order. And this is the language that was drawn out by Ben earlier. The court can be expected to dismiss the claim or may give directions if the documents are not in order. So there's an opening there potentially as a duty advisor to say, you know, a notice that was required under the new regime is missing. You should dismiss the claim, or at least you have to give directions to allow further information to be filed. So it's definitely worth having a good peruse of the documents. Duty advisors should be able to access the R bundle. We'll see in practice how that works. Next slide, please, Ben. Thank you. So the substantive hearing, or S hearings, these will be listed a minimum of 28 days after the R date. And the presumption is that these listings will be in person. Now, courts can agree to parties. If the parties agree to a remote hearing, the court might sign that off, but it's going to depend on what the court's view is in relation to whether that's appropriate. So most of these we'd expect would be taking place in a person. And as with possession proceedings before the pandemic, this is another opportunity for an individual to access duty scheme advice if they haven't accessed it at the R date and been then signed on to, say, a legal aid contract, or even if they've accessed it at the R date and then are re-accessing again at the substantive hearing. So there's a second point for input there. Now, we did have a question before today about attending court in person, and when somebody, say a defendant, would like to bring someone in with them, and whether or not the court can exclude. So I've had a look at the guidance around court attendance during these strange times, and it's fairly clear, sort of obviously, that you're not going to be required to attend if you're clinically vulnerable, or if you've been told to self-isolate, and you're going to need to let the court know as soon as possible. Otherwise, the courts will be enforcing social distancing and the wearing of masks subject to the normal exceptions. Now, the social distancing is relevant because it may be that particular courts only have a certain capacity in waiting rooms, or in particular hearing rooms, for a certain number of people to be there. And on that basis, they may say to a defendant, I'm sorry, but you can't have someone come in with you. And that can be something that can be quite distressing to a person who's in a situation where they're, you know, facing potential loss of their home. So what might you be able to do about that? Well, really it should be a decision made by the court itself if there's a dispute about who can attend, because this is an access to justice issue. Now, and it's also an open justice issue. That the bigger issue really is that justice should be open to the public, so people should be able to observe. It's more that kind of focus rather than this individual needs, say, emotional support. So what you might practically be able to do is, for example, at an R date, you might request a direction from the judge that you're able to bring one person, for example, in with you at any hearing that's listed. Or if an S hearing is adjourned off for a fuller hearing, you might again seek a direction to this effect. If you've turned up on the day of a hearing and you want to bring someone in and they're saying you can't, you might apply to the judge seeking a determination on that basis. But there's going to be a balancing act to think about here, which is you might frustrate or annoy the judge and they might take against the defendant in those circumstances. So really it's a question of how important it is to you. So the overarching principle is that obviously there should be open justice, but this can be constrained where it's sort of necessary on public health grounds. And certainly I imagine there will be circumstances where it's not possible for people to have everyone they might wish to have with them in a courtroom. So if you, for example, made a request of a judge to have a direction that you were allowed to have someone with you and that was turned down, the only thing you can do is probably keep that up your sleeve. If you then have a decision taken against you in that hearing where they say, you know, they make a possession order, for example, it is a potential ground of appeal. So if it was unlawful for the court to exclude someone from the hearing, then any decision made in the context of that hearing will be invalid. But you've got a fairly high hurdle, I would suggest, to get over to suggest that it was unlawful for a judge to decide on public health grounds that people couldn't be there. Now, that was a sort of a little side diversion, you'll forgive me, but we did have a very specific inquiry on that point before the hearing. So let's go back to what S hearings predominantly are about. So it's basically like a first possession hearing you would be used to, although instead of being 5 minutes, it's now 15 minutes long. And the claim will be decided, or it will be adjourned off and further case management directions will be given. Just if we could go to the next slide, thanks, Ben. One thing to note, some concern has been raised about the wording of the overall arrangements, and also we've sort of heard through the grapevine about the steer that the judges who are being trained, the new cohort of judges being trained, have been given. And that's this. So if we read this content in the overall arrangements, there's a suggestion perhaps in that first sentence that we're going to be adjourning off cases that are complex. And there's also been a suggestion we've heard through the grapevine that in some of the training, the importance and the value of a substantive hearing has been emphasised. It's valuable court time. It shouldn't be wasted. If you can make a determination, then you should make a determination. And so there are some concerns bouncing around that it might be that judges are minded to make decisions at S hearings that previously would have been adjourned off for fuller kind of airing. So if we could go to the next slide, please, Ben. I think the important thing to note is that the overall arrangement obviously is guidance. It's not a document that can change the law. And for example, the Court of Appeal in the context of ground 8 claims has made fairly clear that the test is really whether or not there's an arguable defence. So sorry, that was on the last slide there, Ben. And so if you have an arguable defence, for example, an arguable counterclaim that might be set off, that should be sufficient to state that the claim should be adjourned off. And if you've got a judge who's being pushy and saying, well, I'm not sure this is complex enough, can't we deal with it in the 15 minutes? I think it's fair to say that the overall arrangements do not trump the pre-existing position, and that you should stand fairly firm in ensuring that your client is able to get a proper hearing, and that directions for a fuller hearing should be made. Next slide, please. Other things to consider. So the other thing in the overall arrangements that was made clear was that relevant factors to adjournment decisions will be whether somebody has had a chance to gain advice previously. And so things you will want to know before standing up before a court include, did the defendant access duty scheme advice at the R date? Did the duty advisor have access to the R bundle as they should have, so that they could give better advice than they might otherwise have been able to give? And the other thing to note, again, some concern that judges might say, well, you've got this earlier opportunity now that exists to get legal input. You should be ready by today's 15-minute hearing for us to deal with this. I'm unsympathetic to your claim that you should be adjourned off, to point out that there are significant constraints on what can be provided at that initial R date. So it's almost certainly going to be remote. Duty advisors will probably be providing it between the advice that they give at the hearing centre on S hearings. It's going to be time limited. And I understand, I've been told that a feature of the legal aid funding arrangement is that advice can only be provided on the R date that's listed. So if a person misses that window, they can't say, hey, I was meant to get legal advice and I didn't get it, can I have it tomorrow? So it's really important to to point out to judges, perhaps if they're again pushing to adjourn where you think it's inappropriate, that yes, there's an earlier opportunity for legal advice, but that's not going to be a panacea, which means people should necessarily be fully equipped for a full hearing straight away. Last slide from me. Slightly more fulsome here, apologies. So just drawing together some threads on accelerated possession procedures, because I've been talking more generally about claims that will go through the RDAS hearing route. So accelerated possession proceedings are a bit of an exception to that. So normally, as you're aware, they'll be dealt with on the papers, unless there's a defence that needs exploring or some kind of claim of exceptional hardship, meaning that possession shouldn't be granted in the sort of quick time frame. Things to note. As I noted before, you might be able to insert a bit of space into this process if the case is COVID-19 case marked. A judge might put a review date or something equivalent to a review date in if you manage to do that, so that things can be looked at. And that might give you a chance to get legal advice, so potential there. The middle 3 bullet points here are a slightly techie point arising again from some slightly problematic drafting. So you'll recall at the beginning of the session, we come full circle, that I said for accelerated possession procedure claims that with the claim form, there was a need to file a notice that set out the information that the defendant knew about the impact of the pandemic on the defendant. So that has to go in with the claim form, is what PD 55C says. It also says that not only does that requirement apply to all new cases, so anything from after the 19th of September, but that's applied to any case brought after the 3rd of August. Now, the slight oddity here is this. PD 55C only came into force on the 20th of September, but it seems to say that for all accelerated possession claims brought from the 3rd of August, there should have been a COVID information notice filed with the claim form. So we've got sort of a purported retrospectivity here. Now, without getting into the sort of the depth of the philosophy of whether they're allowed to do that or not, I think the critical question here is, what practical use can we potentially make of this? Now, it might be that there's going to be a window in particular for claims for accelerated possession after the 3rd of August and before the 20th of September, where people have failed to comply with this requirement to put in a notice setting out information about the impact of COVID on their tenant with their claim form. What can you do if the documents turn up and this notice is missing? I think there are a few different things that a court might do. I think the sensible thing that they would do would be to adjourn and ask that the information be put in. Nevertheless, it might be that judges who are under pressure, potentially newly trained, might just have a checklist, and they might be looking and saying, okay, I've got a new claim form. It's either meant to have a reactivation notice that gives me this information, or it's meant to have a notice under 6.1 or 6.2 of 55C that tells me that the information about COVID. If it doesn't have either, I'm just going to sort of chuck it out. So you could potentially say at this point, I'm sorry, you're not complying with the practice direction, the claim should be dismissed. So that's again something that you might want to look at, and it's a little sort of strange lacuna in the rules in relation to what happens to claims between the 3rd of August and the 20th of September. Now, we are at 4 o'clock. We knew that this would take a while. I hope you will bear with us because I know that Dominic has some more illuminating things to say next about what happens with reactivated cases, which is also important and complex.
Ben, you're doing such a good job. I'm going to ask you to continue with the slides, I'm afraid, on the basis that my computer will be as good as Alice's. Just before I start, Alice, there was a question on COVID marking criteria in the question and answer, which I inadvertently put into the answers section. If you could have a look at it and just type an answer, I'd be grateful.
Certainly.
So my section of the talk is really about CPR 55C, and it's about how Staid claims. And you'll notice that I've put a slightly different title to my talk. I've put claims brought before 19th September, or should that be the 3rd of August? And save for a few respects, there's going to be a theme running through my talk, which is that the date to think about is really the 3rd of August, not the 19th of September. Ben, do you want to go forwards? So, purpose of the talk is to identify what is now required to progress litigation of all these stayed claims. How do we get these claims started by either the defendant or the claimant? Little word on toolkit. You probably will want to have CPR 55.29. That's the provision that set up the general stay. And that's because it identifies when a claim is subject to a stay, which is one of the definitions used. You will definitely want to have PD 55C, and you may not have CPR 55.A1, but that's what gives rise to 55C. And that practice direction tells us which claims the court will progress automatically and which require a jump start from the parties, the reactivation letters. You will, as Alice has said, want in the background the Master of the Rolls overall arrangements. We're on version 1. They only came out a few days ago, last week. The fact that they've called it version 1.0 suggests that there'll be a few versions coming down the line. So I suspect that's internet searches. And you will probably want to have to hand the 2 reactivation notices which have been created. One is for claimants and one is for defendants, and they are, if nothing else, a useful checklist of what you're meant to put in at the time of the reactivation notice. There are some extras. There's Master Rolls Possession Proceedings listing of priorities. That's those cases which are going to get put to the front of the queue and get a hearing more quickly. I suspect that'll be updated. There's a pre-action protocol for possession claims to social landlords. It's an old document, Ben has referred to it, but you may want to have that to hand for some of the new claims that Alice was talking about. And there is an enormous amount of guidance. There's a few bits in there that you might want to pull out, but I'm not going to go too close to it, but it is there, and it is at least worth looking at some point. Ben. So you've seen this in one of Ben's slides. This is from the overall arrangements, and it's setting out what those arrangements are intended to do. And the arrangements say it's going to be done by legislation, by practice directions, and also by internal guidance. But the key, I think, is in A, and I wanted to highlight them. The purpose of 55C and everything you've heard today is to reduce the volume in the system, to enable earlier advice, and to increase the possibility of settlement, which will take those cases out. Even if not settlement, at least agreement in terms of directions or whatever it might be. Ben. So Alice talked about new lingo that we have to learn, and the bits that I want you to think about with regard to the practice direction, staid claims and new claims. Just deal quickly with the time period in which this practice direction is enforced. It's enforced from the 20th of September, which is obviously last Sunday. So nothing really happens until the 21st. And there is a sunset clause, which is at 28th of March, 2021. So the practice direction disappears on that day. The first concept to think about is a stayed claim. And that is any claim brought on or before the 19th of September 2020, including one that is subject to appeal, which was subject to the stay imposed by CPR 55.29. There are 2 types of stayed claims, and there's only 2 types in the sense that the practice direction deals with these 2 types differently. So the first type is all stayed claims issued before the 3rd of August 2020, and then there's all those issued after the 3rd of August 2020. Now that latter group, in my view, is dealt with effectively as new claims. So really, when you're talking about stayed claims, you're talking about claims that were issued, or the word is brought, before 3rd of August 2020. New claims, theoretically, any claim brought after 19th of September, but I would invite you to treat for almost all purposes, not quite, I've put an exception in there, for almost all purposes, the new claims is any claim brought after the 3rd of August. Now, my understanding is that all claims that arrived on the 3rd of August, you'll forgive me, all claims that were brought after the 3rd of August, I don't know if this is right or wrong, but I'm told that they arrived in the court office and they were put to one side and they weren't dealt with at all by anybody. So I think the reason why they've chosen the 3rd of August is because they have literally been put in a pile to the side, and they will therefore all be issued from Monday onwards, last Monday onwards. Ben. So just before I go into the detail of what the practice direction does, I want to just have a couple of reminders of where there might be some other dividing lines and some other definition points. So firstly, the practice direction clearly only applies to those cases brought under the CPR. And for those cases, there are 3 types of cases, but I've got 2 up there. Those are effectively possession claims by landlords, mortgagees, and licensors, or claims against trespassers. That I would just highlight the way in which trespassers have previously been dealt with differently. So they were not staid claims, but of course it's trespasser claims against persons unknown, not all trespasser claims that weren't stayed. So pre the 19th of September, trespasser cases against persons unknown were not stayed at all. Consequently, the CPR is not relevant, the PD 55C is not relevant to those claims. However, from the 19th of September 2020, the practice direction applies to all claims. That's all CPR 55(2) claims, and those must include, it seems to me, the trespasser claims, whether persons unknown or otherwise. I suspect, and I put in some queries there, does that mean we get review procedures? Does that mean that there's this 14-day notice on this, on the paragraph 6.1 that needs to be dealt with? You'll see what I mean by that a little bit later, but really it looks like a mistake to me, but one that potentially could be used by those who are who want to apply to be defendants in those cases. Really important division is that the practice direction does not apply to any cases where a possession order has been made. So they have no relevance to enforcement of a possession order. Doesn't matter how old the possession order was, and it has no relevance to stay applications either. Those are all governed by the old rules. So, Ben. So what are the main provisions of the practice direction? We've got some divisions as to who they might apply to. What are the big issues that come out of the practice direction in relation to staid claims? So firstly, all staid claims brought before the 3rd of August 2020 cannot be listed, cannot be relisted, cannot be heard, and for accelerated possession proceedings cases cannot be referred to a judge for consideration in the absence of a reactivation notice. Could be from either party. There are some exceptions. I've mentioned one already, which is if there's a possession order in place, then there's no reactivation notice required. But the other key point is that the court can, on application, direct otherwise. Second big change is that any trial date listed, and the theory is that no trial date was listed after the 27th of March because that was the date of the stay. So any trial date listed is automatically vacated unless a compliant reactivation notice is served not less than 42 days prior to the hearing date, or the court directs otherwise. And again, there's opportunity to apply for an early time. That suggests that the court won't necessarily get into its diary and start removing cases. It suggests that the court will wait for somebody to say, what do you want us to do with that trial date? So we'll see how that pans out. But theoretically, that is automatically vacated. It could be the court just takes a clean slate to its entire diary and just starts going again, and maybe lets you put something else back in if they haven't filled it up. Not quite clear what's going to happen. Second big provision, all claims, new claims and Staid claims brought on or after 3rd of August 2020 require the claimant to file and serve notices about any COVID consequences and compliance with social rental protocol. So, apologies, when I say all claims, I mean all new claims or Staid claims brought after 3rd of August 2020. I should really say all other claims. And these two notices, there's no reactivation notice required, but as Alice has told you, there are these two notices required in 6.1, and I'll refer you back to her and what she said about those. Third big provision under the practice direction is the listing issue, which is that the requirement to list non-trespasser cases within 8 weeks is removed. Ben. So let's look at Staid claims pre-3rd of August 2020. Now I know that Staid claims are theoretically also includes claims before the 9th of September, but I want to emphasise again that the date I've got in mind is the 3rd of August 2020. But those claims require reactivation notice. There's no prescribed form, but there are 2 forms available. They seem to be fairly well written out. They've got good reminders of what you need in there. I would be using them if it was me. They must identify the notice must identify whether you're seeking listing, relisting, hearing, or referral. And again, referral is accelerated possession proceedings. Must identify what knowledge the applicant has as to the effect of the coronavirus pandemic on their dependents. And you've heard that phrase from Alice. I'm going to call it for short the COVID information. Alice has pointed out that there is no duty to inquire about the effect of COVID, but I think I agree with her that not only does the claimant form encourage inquiry, but the guidance encourages it, and there's a possibility the court might adjourn. If it's looking at its checklist and it doesn't see anything about COVID, it might think, well, actually I'm going to ask whether that's a mistake or whatever it might be. If it's a rent-based claim, the claimant must provide an updated rent account, and that must be for the previous 2 years. And lastly, if there were case management directions in the claim, there is a load of additional information that is required, and I'll go into that in a slide in a moment. Just a quick note on appeals. One, because there's an oddity, but 2, just to note a slight difference. If you are a Staid claim, and but there is an appeal involved, whether an appeal in relation to an interim order or a final order, that Staid appeal is subject to the same regime, but there is no need to provide COVID information and no need to provide the updated rent information. So you do have to serve a notice, but the additional information sections are not required. The oddity is that a reactivation notice is not required where a final order for possession has been made, and I've referred to that a moment ago. There's no definition of what a final order for possession might be, and although there's some case law in other areas on what a final order might be, the query arises if the appeal is in respect of the final order for possession, is a reactivation notice required? Because of course there's no need to serve one if there is a final order for possession in place. I think, so it's slightly unclear, but I suspect the court is likely to say that there is no final order if it is the possession order that is being appealed. And that's just me taking a view, others may argue otherwise, but the real point is, if you want to get your appeal going again, I suspect the court isn't going to do anything without you serving that reactivation notice. Ben. So what is going to happen to your case if, when the reactivation notice is served? What's the consequence of it? Well, we've seen from Alice that in relation to examination of possession proceedings, it's going to be a request for a referral to a judge, and it's going to go and be dealt with on the paper proceedings. What about a request for listing or relisting of any hearing? Well, the first point is the court must give 21 days of the notice of a new hearing, unless it directs otherwise, which is, I assume, going to be pursuant to an application. So let's say you wanted to save a trial date. March 2020 came along. You were weeks away from your final directions. You've dealt with them all now. You had a trial listed for 5 days. It's in October. You don't want to lose it. It seems to me that you'd need to act pretty quickly, bearing in mind that 21 days. And to my mind, the court is only likely to shorten the notice period if your case is on the priority list, the Master Rolls priority list, and there's agreement that there's no prejudice as a consequence of the stay. If the case has no directions, and you're effectively in the normal, absent all these new provisions, you would have been expecting a first return date, it's likely to go down the review date and substantive date structure that Alice described. If you have already had what you might call the first return date, the CPR 55.8 hearing, and directions have been made, whether full directions or limited directions, it strikes me that when you resurrect that case, you'll either get, if you agree directions, you'll either get an order or you'll get a case management hearing to see how to deal with it. That would be my suggestion then. So the additional requirements when you serve a reactivation notice, if you have got directions, let's have a quick look at those. So if you've got case management directions, the applicant, can be a claimant or defendant, has to serve a copy of the last directions order and any suggested new dates for compliance, a draft order setting out any additional alternative directions, including any directions in relation to hearing dates, or a statement that no due directions are required and the existing date can be met. Now that last requirement does suggest that the court is going to be keeping those dates in for a little while to see what people say. But it's a bit of guesswork on my part. And the third thing that you need to serve is a statement whether the case is suitable for hearing by video or audio link. The other party, whoever that might be, has 14 days to file a written response. And it seems, again, I said this already, it seems to me that the procedure is set up in a way that will allow a judge, as soon as those papers come in, to look at them on the papers and or list for a case management conference if there's a dispute. If this is just something that I would suggest, if you've got some controversial directions, the equivalent of effectively asking for new statements from new people who haven't previously, where statements have previously been required and the data's gone, strikes me that you probably would want to include an N244 application with evidence explaining why your controversial directions, as it were, required. I wouldn't rely solely on the reactivation notice. Ben. So I've produced a summary, which you can look at your leisure when you download the slides, which are available, I think. And you can see there, I put a little bit about mortgage cases, which is a tiny little bit, which I'm going to leave to one side. But you can see there that, for me, the date of cutoff, save in respect of trespasser persons unknown cases, is really the 3rd of August 2020. And you'll see that I've got a column telling you when you need a reactivation notice and a comment telling you what else you need to include. So hopefully that will make a little bit of sense given the talk we've just had. Ben. My ability to turn my phone off is fantastically poor. A quick word about what happens if nobody does anything. That if no reactivation notice is sent in by 29th of January, there's an automatic stay. If there's a reactivation notice and directions are previously been made, but none of the requirements, the additional information in relation to directions is provided, there's an automatic stay. Any party may apply to lift the stay, and it's not treated as an application for relief from sanctions. So the court appears to be relatively relaxed about that. Ben, go on. And lastly, a word on, I think it's my last slide, a word on enforcement. So I've obviously explained that as soon as the stay was lifted on Monday, existing possession orders can be enforced. 55C doesn't require any further steps, it says nothing about the enforcement stage. So a few extra bits on that. MOJ has issued instructions to bailiffs. Firstly, in what I've called whack-a-mole areas, nothing like Boris Johnson's expressions, in those additional restriction areas, bailiffs have been told that they can't do anything. And there's, I think it's a 6-week period over Christmas in which they've also been told that they can't do anything. And I'm not entirely sure of the dates at the moment. Bailiffs are now required to give 14 days notice. That's the same in the High Court and the County Court. And where warrant applications have already been issued, i.e. before 21st of September, there's no need for a further application. Bailiffs are going to pick up those applications and landlords will start getting their dates. And those eviction dates will come out in accordance with the Master Rolls priority list and thereafter by the date of the application. Apologies for the interruption of my phone. I should have turned it off. Classic Dominic stupidity. And I think there are some questions. Ben, I'm going to hand over to you in case you've been looking at some of those questions. If there are any for me, I'm happy to answer them.
Thanks, Dominic. Nathaniel's just asked I think a really interesting question. How does reactivation notice apply if the defendant has an existing counterclaim? Well, my reading is if you look at the new Practice Direction 55C, it says pretty clearly that unless the court directs otherwise, no stayed claim is to be listed, relisted, heard until one of the parties files the notice. So, I mean, it seems to me that even if you've got a disrepair counterclaim, for example, that you really want to crack on with, nothing is going to happen until you file that reactivation notice. That's the way I read it. Dominic, have you got a view on that?
Well, I think that would also be confirmed by one of the Court of Appeal cases, I forget which one, that dealt with these different cross claims in the context of the stay. And it talked about what a claim was and what a counterclaim was. Yeah. I'm fairly sure that that would incorporate, by analogy, all counterclaims are covered by the practice direction.
Yeah. There's another question posted from Oliver Conway. If a stay claim brought pre-3rd of August has a hearing listed and no reactivation notice, is it better for D to attend and argue the same or apply to the court pre-hearing to have the hearing stayed? This is a difficult practical one, isn't it? My instinct would be try and contact the court to get the hearing vacated, because what that Arcan case, which I think is the one that Dominic was referring to, makes clear is that the practice directions take effect automatically. So it seems to me that these should have had the effect of automatically removing all these hearings from the list. And if that hasn't happened, it's something you ought to just raise with the court and tell them that it can't possibly go ahead. And indeed, even if you want it to go ahead, and even if you agree with the other side that it should go ahead, you pitch up on the day, you may find the whole thing is just not going to happen, or that the court refuses to deal with it. So I think you've probably got to try and deal with it in advance.
There's a slight element of confusion about that, and I wasn't quite sure what the answer would be. In the overall arrangements at paragraph 38, it says, unless there are existing case management directions that provide otherwise for both staid claims and new claims, the first date to be listed is a review date. Now, I think that that's referring to standard cases, but it seems to me that if there is a validly listed hearing, then it might go ahead. But of course, the whole point, I think this is what you were saying, Ben, is that all hearings, whatever type of hearing, are vacated by the practice direction, and therefore it seems to me that they are vacated unless the court tells you otherwise. So yes, I agree. You'd want to just get in contact and say, does the court want us to go ahead? And maybe I would have thought, try and come up with an agreement with your opponent in any event as to how you want that hearing to be used. But yes, theoretically it's vacated, but there is this slightly odd wording in the overall arrangements.
We've got one other helpful post from anonymous attendee. Says that Xmas truce dates are 11th of December 2020 to the 11th of January 2021, which is really helpful. Then there's just a couple of other questions. Dominic, do you want to have a look at the one that's addressed to you?
I haven't seen it. Let me just double check it. This one. What happens for emergency applications for evictions to be stayed? Do the new regulations envisage new protocols for defence applications to stay the evictions? So there is no change. This is the slide on enforcement that I've got that's up at the moment. There is unfortunately no change to the enforcement provisions. And indeed, as I say, that the pile of eviction applications that have been issued since March, assuming that they were allowed, have presumably stacked up in the bailiff's offices, and they will go through them and eventually pick a date. So if your client is in need of some relief from the court, make the application.
And then I think we're just perhaps time for one more question. Again, really interesting one. We've already started receiving claim forms dated as issued 6 months after the date of NSPs served prior to lockdown. But from what you're saying, the date of issue on the claim form may reflect a very much later date after the claim form was filed.
Yeah.
Is this correct? I think because the suspicion is the court office has just been sitting on all the claims, not stamping them.
Yeah, Ben, you go ahead first.
That's really interesting. I don't know the answer to that. It may well be true. What are the consequences of it? I mean, certainly if it's if it's a homelessness appeal, and you're needing to show that you issued it within the 21-day deadline, it's the date of delivery to the office that actually matters. I mean, we'll have to check whether the same applies to claims for possession, but I suspect it does. And it may well be that you have an argument about when the landlord actually delivered the claim form to the office. Unless, Dominic, have you got anything further on that?
No, I'm just checking the practice directives. I think it's that the phrase, and I've used it interchangeably in the slides, which I probably shouldn't have done. So a staid claim is a claim which is brought on or before, and it uses that phraseology of brought. And I've got a feeling that somewhere in the overriding arrangements, or the arrangements, overall arrangements that we have published by the Master of the Rolls, that it talks about the relevant date being the date in which it's brought, i.e. it arrives in the office, not the date on which it is you are informed it was issued. But of course that may mean that it's for the claimant to show that the court has put the wrong date on, and therefore you may want to say something about it. It might have some relevance to the way in which Alice's accelerated possession proceedings point was raised. this uncertainty about what information is required to be served with accelerated possession proceedings that were served between 3rd of August and the 19th of September. Because it may be that they all come out with date 21st of September or afterwards. But it could be that the defendant knows, and consequently you can find out that actually it was issued beforehand, at which point there should have been a notice.
And of course, it might matter for the claim because of the substantive law. I mean, it may be that the landlord has to show he's issued within the lifespan of the notice, whether that's a Section 21 notice or Section 8 notice. And looking at Section 21, the wording is that proceedings may not be begun after the end of the period of 4 months or 6 months or 10 months, whatever it is. So it may well boil down to what's meant by the words begun, and can the landlord prove that they actually delivered the claim form in the required time. So that there might be some interesting points about that.
I agree. I suspect it's going to be not so much about what is the bringing of a claim. I think most people will say it's getting it to the office. We've got the 204 cases that you mentioned. But the real issue is going to be proving which date it was and arguments about when it was. And again, that potentially may give you opportunity for delay and time to deal with matters if you've got nothing else.
They're really good questions. There are lots of other really interesting questions posted on the Q&A page, which, but I think we probably kept you for way long enough. What we might try and do is go through those and answer them, and I think they will then be available. We'll try and make them available through the website, along with the slides and along with the recording. But I think that's probably where we'll end the webinar for today. So thanks very much for joining us. I hope you found it helpful, and we hope to see you again soon. Thanks. Bye.
Yes.